Hi, my name is Charlotte Flowers, and I'm going to discuss these two cases. New York Times versus Sullivan is my first case from 1964. The facts of the dispute are as follows. L.B. Sullivan, an elected official of Montgomery, Alabama, claimed that the New York Times published an advertisement that defamed his character. The defendant claimed that it had no reason to believe the contents in the ad were false and therefore did not check for accuracy. The ad, Heed Their Rising Voices, claimed that while a group of Negro students engaged in a nonviolent demonstration for affirmative action as guaranteed by the U.S. Constitution and the Bill of Rights were attacked by truckloads of police armed with shotguns and tear gas on the Alabama State College campus, and their dining hall was padlocked in an attempt to starve them into submission. Now, some of these allegations were found to be false. The plaintiff's name was never mentioned in the advertisement, but he argued since he was the supervisor of the police department at that time, the ad must have referred to him also. Here's an image of the article, Heed Their Rising Voices. The Alabama law on defamation states, in order to prove defamation, the plaintiff must show that a defamatory statement was made regarding him and that it was false and not an opinion. The defamatory statement was published with a certain degree of fault and cause injury to the plaintiff. The statement must hold up the plaintiff to public hatred, ridicule, or scorn. The U.S. Supreme Court ruled that the court ruled in favor of the defendant, citing that the Constitution delimits a state's power to award damages for libel in actions brought by police officials against critics of their official conduct. In this case, the rule requiring proof of malice is applicable. In the second case, Gertsch versus Welch, the plaintiff Gertsch filed a defamation lawsuit against Welch for claiming that he was the mastermind behind a frame-up for bringing a lawsuit against a local police officer who killed a child and implied that Gertsch had a criminal record. The rule of law states that a private individual involved in matters of public concern may recover for actual damages if they prove that defamatory statements were actually false and negligently made by the speaker. Now, here are the facts of this case. The defendant Welch, a magazine publisher, warned his readers of a national police organization that supported communism. In an article he published, he accused the plaintiff of being an official of the Marxist League for Industrial Democracy, also referred to as the Intercollegiate Socialist Society, which advocated the violent seizure of the government and also stated that Gertz was an officer of the National Lawyers Guild, which was described as a communist organization. The managing editor of American Opinion made no effort to verify or substantiate the charges against Gertz. The article was published in the American Opinion magazine and distributed and sold throughout the country and on the streets of Chicago. These allegations against Gertz injured his reputation as a lawyer and as a citizen. Now, in my opinion, had I been Welch, I would have done more fact-checking to ensure that I had proof of my allegations against Gertz. In Arkansas, the defamation law requires that the plaintiff show proof of how the statement caused him harm or reputation loss, that the material in question referenced the plaintiff, that the defendant is responsible for publishing or speaking the statement under review, how the statement caused harm, and what types of damages the statement caused. What I've learned from these two cases are that it is very important to fact check my information thoroughly and to understand the various defamation laws for each state. I now also understand the difference between libel and slander and the laws as it pertains to a public official and a private person when it refers to a defamation lawsuit. And these are my references. Thank you. I hope you enjoyed. Goodbye.